Well, hello everyone, and welcome to Uncivil Law. I hope, as always, you are having a fantastic day. I'm having a better day. For those of you who are worried about me being sick the other day, I'm feeling much better, and thank you. We are here today with Parler's suit against Amazon, or more specifically, I suppose, Amazon Web Services. So, as I'm sure most of you know, Amazon does many things, and one of the things that is most profitable for them, and one of the things that they're perhaps most notable for, is their cloud services. They do 50% of all the cloud services for the public clouds. A lot of companies, of course, have their own private clouds, and they have their own servers, but Amazon does a lot of business on their cloud servers. Amazon Web Services is a huge profit center for Amazon as a company, and so they provide cloud services. So if you need computing power, you need somewhere to store your stuff, you need all that stuff, Amazon will sell to you, unless I guess you're Parler, because they have unsold to Parler. And Parler is suing for this violation, breach of contract, and some other causes we'll get to. Parler, of course, is a free speech app, has some notable right-wing kind of tendencies to it, which is fine because other apps have more left-wing tendencies. But apparently this is unacceptable to the powers that be, to Amazon, who have kicked it off. And presumably, having been kicked off the major service of Amazon, it will be less likely to get hosting from another major service. So that means either they have to use one of the smaller services, of which there are many, or they have to roll their own, or whatever. So no matter how you slice it, it is a problem for Parler. And they're going to be trying to figure out that for a little bit of time because it's a big deal. So anyways, we're going to take a look at their lawsuit and we'll try to judge whether or not what we think the merits are. We don't necessarily have all the information at this time because we just have the complaint. We don't have the contract yet, so it's a little bit hard to judge some of the claims, but we'll do our best and we'll see where we go from there. So let's do that. Great. We have the case of Parler versus Amazon Web Services, which we are using in the Western District of Washington, which is a good place to do it because that's where Amazon is based. So that makes that easy. Personal jurisdiction, that's easy. That's where Amazon lives. Okay, great. So we're going to sue them in their home turf, which that's fine. It's a fine place to sue them. Parler, by its undersigned counsel, alleges and verifies the following. So this is verified, which means it's under oath. So the things that are in here can be taken as, under the penalty of perjury. So this is civil action for injunctive release, including a temporary restraining order and preliminary injunctive release and damages. So I suppose they're also going to file a TRO in a separate document for a temporary restraining order. And they'll see if they can get the court to force Amazon to do something right away. No, almost certainly not. But they're going to ask. They're going to ask for the TRO. The problem for Parler is that one of the things that you look for in a temporary restraining order or a preliminary injunction in particular is whether or not there's any sort of harm that can't be fixed later. Is there any sort of harm that will occur that a theoretical court award at some point in the future can't solve? And the problem is that money is never considered to be irreparable harm. We can always if money will solve the problem, we can always give you more money later, and that will make you whole. We can make you whole with money. So if money is your damage, then money will make you whole. And it's hard to see immediately how they have non-monetary damages. Now, Parler's going to try. They're going to say, well, we're going to lose out on all of our potential people who would use our platform because we had so much traffic coming our way. They're going to say we are losing the ability to acquire those customers at a time when people are looking for alternatives to Twitter. And so we won't be able to recapture those users, which means we won't be able to recapture the advertising revenue or other revenue or the increase in popularity that we would obtain from that. So Parler's going to try to make some irreparable harm claims, but it's a little bit hard to see how it's like, yeah, but we'll just give you a big pile of money. Doesn't solve those problems, but they'll try. Last month, defendant Amazon Web Services and the popular media platform Twitter signed a multi-year deal so Amazon Web Services could support the daily delivery of millions of tweets. I'm sure they did. It is a major, does 50% of all the web traffic. Amazon Web Services is huge. Not all the web traffic, all the cloud service traffic. I should be more specific. Amazon Web Services currently provides the same service to Parler, a conservative micro-blogging alternative and competitor to Twitter. Sure. Yeah. When Twitter announced 2 evenings ago that it was permanently banning President Trump from its platform, conservative users began to flee to Twitter en masse for Parler. Yeah, so they're going to say we are being harmed by not being able to capture people, because if we're down for a week or we're down for a month while we're trying to do this, we'll never be able to recapture those users. And Amazon's counter argument will be, yeah, but if you win, we can give you a big pile of money from which you could advertise and get those users and so forth and so on. So money would fix your problem. But that's what they're going to probably argue about if I had to guess. So the exodus was so large that the next day, which was yesterday from the perspective of this lawsuit, Parler became the #1 free app download on Apple's App Store, which of course then it was removed shortly thereafter. Yet last evening, Amazon Web Services announced it would suspend Parler's account effective as of Sunday, January the 10th at 11:59 p.m. Western Time, Pacific Time, and stated the reason for the suspension was that Amazon Web Services was not confident Parler could properly police its platform regarding content that encourages or incites violence against others. However, Friday night, one of the top trending tweets on Twitter was, "Hang Mike Pence," but Amazon Web Services has no plan nor has made any threats to suspend Twitter's account. So they're trying to say there's some duplicity in the way that they're applying their policies. So they're saying, well, Amazon has policies that would prevent people from encouraging or inciting violence, but they're doing nothing to Twitter. They're treating them treating these in an unequal way. So they're in violation of their own policies. They're not, and that disparate treatment could be a potential problem when it gets to an antitrust, which is part of their claim. So they don't have an equal protection claim, but they're going to try to say that it's basically a pretext and it forms an antitrust. And I don't know if any of that will work, but they will certainly try. Amazon's decision to effectively terminate Parler's accounts is apparently motivated by political animus. Well, that is a valid motivation, unfortunately. You can discriminate against people. You can discriminate against companies for political affiliation, and in most states, you can discriminate against people for political affiliation. I believe it is technically illegal in D.C. I'd have to double check, but I think it's also illegal in California, although those are very narrow. So for the political associations, but as a matter of federal law, it's legal. So if Amazon Web Services did it because we don't approve of their politics, Amazon can just say, yeah, we did it because we didn't approve of their politics. So what? Yeah, we're allowed to have that as a motivation. It's also apparently designed to reduce competition to market to benefit Twitter. Well, if it were truly designed for that purpose, that would be an antitrust issue, as opposed to being a collateral consequence. If it's a collateral consequence, it's not antitrust. If it's designed for that purpose, it is antitrust. That would be unfair competition if it was truly designed for that. But good luck on proving that was their goal and purpose. Thus, Amazon Web Services is filing Section 1 of the Antitrust Act in combination with Twitter. Yeah, Section 1 is the great one. It's like every conspiracy, agreement, device, blah, 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 that restrains or constrains trade is declared to be illegal. So if you have an agreement, conspiracy, arrangement, device that restrains trade, that's illegal. So basically you're looking for something that they're doing in concert, and that would be hard. Amazon Web Services is also breaching its contract with Parler, which requires Amazon Web Services to provide Parler with 30 days notice before terminating service, rather than less than 30 hours notice Amazon Web Services actually provided. This is why it would be very helpful to have the contract, which we don't have at this point. Presumably, Amazon will provide it as part of the response, whether that's motion to dismiss or otherwise, where they'll provide the contract, and we'll be able to see what exactly the requirements are for notification and whether there's some sort of emergency provision. So I'm going to guess, without looking at the contract, because I don't have it, but I'll take a reasonable guess that Amazon Web Services has, if you violate our rules, you get 30 days notice, and then they have some sort of emergency clause. In the face of a blatant, rampant violation, we can take immediate action, blah, blah, blah. And so that's probably the one that Amazon would say. I mean, we can just infer that just by being reasonable people. Let's just think about what Amazon probably has in its contract and what kind of provisions they would write to protect themselves. So is the 30-day provision the only thing that they have in their contract? Probably not. So we will read a little bit more. Thank you for the super chat. Canadian dollars from Living Sweetly. Amazon is a privately owned company? Sure. Of course. That means that they're not bound by the Constitution, but they are bound by certain statutes. So that's true. They're not bound by equal protection under the 14th Amendment. They're not bound by the First Amendment under the First Amendment. But there are statutes that apply that might be relevant, such as the Antitrust Act, where there's things that they can't do by statute. Parler is endorsing national security risk and threats by breaching Amazon's policy and national security laws. Well, if they were truly breaching national security laws, one would imagine that the government would be after them in some way, and to the extent they're breaching Amazon policies, that might be part of Amazon's response. They're breaching our policies, they're doing so in a blatant way, so we have the right to terminate their service and whatever. So that's why it would be helpful to have the contract so that we could parse the exact language and see what Amazon's rights are or not. Although without the contract, we can reasonably assume that Amazon's rights are pretty broad because, Amazon is not an idiot. So we can assume that they have provided for themselves very well in their own contracts. So, without even reading their contracts, we can assume that Amazon has put all kinds of interesting defenses in their contract. But thank you for the super chat. The emergency suit seeks a temporary restraining order against the web services to prevent it from shutting down Parler's account at the end of today. Doing so is the equivalent of pulling the plug on a hospital patient on life support. It will kill the business at the very time it's set to skyrocket. Well, that's a little bit hyperbolic. It would be a problem, but it is probably a problem that can be solved with a big pile of money later, at least arguably. So this has subject matter jurisdiction because it's antitrust, supplemental under state law. The court has personal jurisdiction over Amazon Web Services headquartered within the district. Yeah, no problem. Their headquarters are there, so it's easy per personal jurisdiction. Venue lies in the district because Amazon Web Services maintains its principal place of business. Unless the contract says otherwise, and it probably doesn't. I mean, if I were a betting man, I would say that the contract probably says that jurisdiction and venue should be here. Again, I don't have it, but I'd take a guess. If it sets it here because Amazon would want it on its own turf. So this probably is what the contractual language has too. The plaintiff is a Nevada Limited Liability Corporation with its principal place of business in Nevada. They didn't want to argue diversity jurisdiction on top of federal question jurisdiction? Interesting. Parler is the solution to problems that have surfaced in recent years due to changes in big tech policy influenced by special interest groups. Thus, Parler is built on a foundation of respect for privacy and personal data, free speech, free markets, and ethical, transparent corporate policy. Defendant Amazon Web Services, an Amazon Incorporated company, is a Delaware company with their principal place of business in Seattle, Washington. Yeah, that's right. So they might be incorporated in Delaware because every company on the face of the earth is incorporated on Delaware. But you also have, for companies, you also have jurisdiction not only where they're incorporated, but their principal place of business, which is undisputably in Washington. That's where their headquarters are. That's where their sea level floor is, right? So yeah, you have general personal jurisdiction in Washington, no problem. Amazon Web Services is a world-leading cloud provider, capturing a third of the market. I think it's more than that. I think it's half. This is almost double the next largest competitor, equal to the next three largest competitors combined. Amazon Web Services generates tens of billions of dollars in revenue. That's definitely true. It's very profitable for Amazon. According to its own press release, for 14 years, Amazon Web Services has been the most comprehensive and broadly adopted cloud platform. This is why millions of customers, including the fastest growing startups, largest enterprises, and leading government agencies, trust Amazon Web Services. In short, Amazon Web Services is the Rolls-Royce of cloud platform providers. That's a reasonable characterization, and I'm sure Amazon likes being described as the Rolls Royce of providers. So we're not the Rolls Royce of providers. Yeah, you don't see Amazon saying that. All right, so here's some facts. Let's do some facts. Parler contracts with Amazon Web Services to provide cloud computing services Parler needs for its apps and website to function. Sure. Further, that both the apps and website are written to work with the technology. Sure. To have to switch to a different service would mean rewriting the code, meaning they'll be offline for a financially devastating period. I don't know how hard it would be to rewrite the code. If you have to really rewrite the code, then the code wasn't written very well. It should be a relatively easy thing to change, but maybe it's not. Maybe Amazon Web Services is designed in such a way that the code is written in such a way that's more than a simple replace. So I wouldn't know how the code is written, but maybe they're right. Maybe it would be offline for a substantial period of time to rewrite that code. Parler is also a competitor of Twitter, as both provide similar platforms for users to communicate with short messages, links, and pictures. Like many social media platforms, Parler business model is not based on subscription. Less than a month ago, Amazon Web Services announced with a new press release a new multi-year deal with Twitter. Amazon Web Services will provide a global cloud infrastructure to serve Twitter timelines. All right. According to the deal, Twitter will leverage Amazon Web Services' proven infrastructure to support delivery of millions of daily tweets. Further, this expansion onto Amazon Web Services marks the first time Twitter is leveraging the public cloud to scale their real-time services. Really? I'm surprised by that. I would have thought that Twitter would have used public cloud services long before this, given the volume of things on Twitter, but I guess up to this point they've been rolling their own, which is fairly expensive. It might be one of the reasons that Twitter has such financial problems, but it surprises me that they haven't used public infrastructure till now. The deal built on companies' more than a decade-long collaboration where Amazon Web Services to provide Twitter with storage, compute, database, and content delivery sources. Okay, I don't understand how to juxtapose those two sentences. It's the first time Twitter is leveraging public cloud, but Amazon Web Services has been providing storage, computing, database, and content delivery services. I don't understand how those two statements exist in the same universe, but sure. Mike in chat says, the app code's not itself likely not a problem. It's probably all the infrastructure to deploy, config, and source codes to live within Amazon Web Services. Yeah, that was what I was kind of alluding to, but poorly. So yeah, I think that's exactly right, Mike. It's like whatever custom coding they had to do to live within Amazon Web Services structure or to use it more efficiently. So that was exactly along the lines I was thinking. But thank you for the clarification, because I could have said that more clearly. Let's see. What is more, together Twitter and Amazon Web Services will create an architecture that extends Twitter's on-premises infrastructure to enable them seamlessly run and scale the real-time services globally, increase reliability, and rapidly move new features into production around the world. That's awesome. At the same time, Parler begins to significantly increase its usership at the expense of Twitter. After the election in November, the New York Times reported that millions have migrated to alternative social media and media sites like Parler. In fact, less than a week after Election Day, between November 3rd and November the 8th, Parler's app experienced nearly 1 million downloads. Okay. This resulted in Parler's rocking to be the first #1 free app in the iOS App Store, up from 1,023rd just a week earlier. Well, that's a pretty big that's a pretty big against. Internet Commentator says, did I buy subscribers? No, I didn't buy subscribers. Internet Commentator, you know better than that. But for some reason, the Streamlab bot seems to hoard the subscribers and then announce them all at once. I don't know why it does that. I don't know why the bot does that, but it does. And then it's like, oh, I realize I have 20 new subscribers I should announce. So, that's fine. No, I don't buy subscribers. That's lame. Likewise, in the same week, Parler went to 486th to first in the Google Play ranking. Not surprisingly, the app was the 10th most downloaded social media app in 2020 with 8.1 million new installs. In 2021, this trend not only continued, it accelerated, thanks to Twitter's announcement 2 days ago that would permanently ban President Trump from its platform. On that last day, last Friday, Parler saw installs increase in the United States by 355%. So they're showing here the harm. This is why they're doing this, right? To go to the harm, to show their growth, show how they're developing, show that how they were on a rocket ship, that Amazon is diminished, is taking away. So they're trying to go, this is basically trying to show irreparable harm. We'll never get those subscribers back. We'll never get that back. Money won't make us whole. That's why they're trying to do this. After Twitter's announcement, conservative politicians and media figures began encouraging their followers to switch to Parler. Speculation began to mount that President Trump would likewise move to Parler. Given close to 90 million followers the president had on Twitter, this would be an astronomical boon to Parler and a heavy blow to Twitter. Well, apparently Twitter doesn't see it that way because Twitter canceled his account already. So Twitter apparently doesn't see it as a heavy blow, or they don't care. So Twitter apparently disagrees with this. Given the context of Parler's looming threat to Twitter and the fact that Twitter ban that might not long muzzle the president if switched to Parler, potentially bringing tens of million followers with him, Amazon Web Services moved to shut down Parler. It's suggesting a particular motivation for Amazon, which is a little less developed. It's speculative. Yesterday evening at 6:07 p.m. Pacific time, website BuzzFeed posted an article with screenshots of a letter from Amazon Web Services to Parler, informing Parler its account would be suspended as of 11:59 on Sunday, less than 30 hours later. Strangely, the article with the letter was posted before Parler itself received the letter in email, received at 7:19 p.m., over an hour after the BuzzFeed article went online, meaning Amazon leaked the letter to BuzzFeed before sending it to Parler. Maybe. Last week, the Associated Press reported that Parler may be the leading candidate for President Trump after his Twitter ban, as experts had predicted Trump might pop up on Parler. It's a reasonable guess. It is a major app that the right wing has been using for some time. So in lieu of Twitter, Parler would be a logical choice to use. You sent me the contract on Discord? Excellent. When we're done with this, we'll take a look at the contract and we'll analyze it in light of specific things. So that's fun. Thank you, Matt. However, the AP also observed that Amazon struck a blow Saturday against the chances of Trump adopting the platform, informing Parler would need to look for a new web hosting service effective midnight Sunday. The death blow by Amazon Web Services could not come at a more explosive time for Parler, a time when the company is surging. So this is, again, trying to go to irreparable harm. We cannot be made whole later. So we need the court to do something about this now. The court is not going to do something about this now. There's just no way, because the big pile of money solves many problems, and the court's not going to do this. Worse than the timing is the result. Parler had tried to find alternative companies to host it, and they've fallen through. It has no other options. Well, that's again trying to go to irreparable harm. So we can't, because if we one of the things you look for in breach of contract is you have a duty to mitigate. So if someone breaches a contract with you, you still have to mitigate the damages. So you have to try, as best as you're able, to fulfill your needs elsewhere. And then you can sue them anyway, but you have to mitigate them to make the damages less bad. And so this is doing two things. It's saying we have irreparable harm because we have nowhere to go, and we can't mitigate our damages. So we're trying to do two things with this. A delay of granting this TRO by even one day could also sound Parler's death knell as President Trump and others move to other platforms. It's no wonder then the competitor's CEO has hardly endorsed efforts to remove Parler from the public sphere. Well, he's allowed to have an opinion and express that opinion. When you're thinking about antitrust, though, you're thinking about actual coordination, which is basically an agreement. So Twitter saying we think this would be good, and Amazon also saying we think this would be good, is not coordination. It's just two people saying the same thing that are agreeing. And then they have a footnote here about Amazon Web Services indefinitely suspending Parler is categorically different than Google or Apple dropping Parler. In the instance of the latter, the existing Parler users can still use the app. It's just harder for Parler to sign up new users. But with Amazon Web Services move, both existing users and new users are completely prevented from using the app until Parler can find some other service. Users are also prevented from using the website, which is likewise dependent. So this is again going to irreparable harm. Internet commentator says, wouldn't the government contracts relying on Amazon Web Services cut against public interest? I don't think that is relevant one way or another. I don't see how the government having contracts with Amazon Web Services speaks to the public interest or not. I don't think it's relevant. I do believe it's illegal in Washington State. What, to discriminate on the basis of political affiliation? Again, you have to look very specifically into how that law has been interpreted by the relevant courts. In California, it has been interpreted very narrowly. So it might be illegal in Washington to discriminate on the basis of political affiliation. But what that actually means in practice, you'd have to look for the case law. The impression that you'd come away with by reading the statute in California is definitely not the right understanding. California's courts have interpreted it very narrowly. And so, Washington statutes may say that, but you have to actually get into the case law. So, Parler's rival social media apps such as conservative-oriented Gab or conservative media Rumble are also experiencing record growth. If Parler is not available, people turn to alternatives or perhaps return to Twitter or Facebook. What is more, Parler's current users are likely to leave and go to another platform if Parler is down for an indefinite period. And once those users have begun to use it, they may not return to Parler. So again, going to irreparable harm. And by silencing Parler, Amazon Web Services silences the millions of users who do not feel their free speech is protected by Twitter or other social media apps. What is more, by pulling the plug on Parler but leaving Twitter alone, despite identical conduct, one can debate how identical it is, but at least comparable. Amazon Web Services reveals that expressed reasons for suspending are but a pretext. Yeah. So this is going to the element in the contract, which we were going to read in a minute, that is allowing Amazon Web Services to do this. So Amazon's Web Services is going to be saying, you violated this provision of our contract, and it allows us to do this. And they say, well, other people are doing it too, and you aren't taking action against them. And then Amazon Web Services' response will, be that as it may, we can waive conditions if we want as the contract holder, which they can. Just because they are violating provisions of our contract, we're allowed to waive those conditions, which they are, right? Just because someone has breached the contract doesn't require you to care. You're allowed to care, but you're also allowed to not care. So if you have a contract with someone and that person breaks the contract, you're allowed to not care. That is a viable option. You're allowed to waive it or forgive the condition, right? So they're going to say it's but a pretext. You're treating all these other businesses differently. And Amazon will say, even if we are, so what? We're allowed to do that. We're allowed to waive conditions. We're allowed to not hold conditions. We're allowed to not care if we want. We care when it comes to you. We don't care as it comes to them. We don't have to be equal in our treatment about it. And then Parler was going to say, yeah, but this is really a collusion thing and antitrust and all the rest of it. And they're going to say, no, it's not collusion. We all drink from the exact same water, and so we all think the same. We're not actually talking to each other. We just all belong to the same. We all drink from the same water, and so we all think the same. But that doesn't mean we have an agreement. We're just basically in one hive mind. And then, yeah, that's basically how that will go, probably in the exchange. Parler has problems. Yeah. Parler's lawsuits has problems. They have many problems. And also there's got to be an arbitration provision in this, right? I mean, without even reading the contract, there's got to be an arbitration provision, right? Which means this whole thing gets shipped off to arbitration and we never hear from it again. Which is also why they're moving for the injunction. They'll spend a year dicking around on that before they actually get to arbitration. But yeah. What's more, by pulling the plug on Parler, but by leaving Twitter alone despite identical conduct, Amazon Web Services reveals that it's suspending it are a pretext. No, it's not a pretext. We just didn't care about the other ones. In its noting announcing the pending termination of Parler, Amazon Web Services alleges that over the past several weeks, we've reported 98 examples to Parler of posts that clearly encourage and incite violence. Amazon Web Services provides a few examples, including one that said, "How about them hang?" followed by a series of hashtags, including "FU Michael Pence." That's nice. $10 from Trivium. After watching yesterday's batch record, I couldn't help but wish my college professors were like you. That's very kind of you. Thank you. Sensitive, sexy, and intellectually honest. I think you're quickly becoming my favorite YouTube lawman. Well, that's very, very kind of you. I appreciate it. I also think I'm better than most law professors. You know, when I judge the quality of my content, I look at the quality of YouTube. I look at the quality of most presentations by law school people on like video, and it's all horrible. It's all atrocious. I don't know what the problem is exactly, but when I do CLE, when I do continuing legal education, I do them on video. And every time I watch a continuing legal education by a lawyer, I want to die inside. It's horrible. It's just all horrible. I don't know what the problem is exactly, but most law professors, in fact, almost as a universal truth, all of them, all the law professors, basically, asterisk, some exclusions may apply, but all asterisk law professors are just horrible. Horrible on video. And so, like, yeah, I feel pretty good over here with being the top 1%. Because I don't have a lot of competition. They're all just universally bad. I don't know what the problem is, but they're all horrible. Yeah, but thank you for the super chat. I remember when I was doing some Barbary videos in prep for the bar exam. I wanted to cause self-harm. It was bad. It was really, really bad. Really, really bad. Have you ever seen those, some of you might have done it for real, but have you ever seen like corporate new hire videos? You know, have you ever seen like the corporation, please enjoy this video presentation for your first day of the job. Welcome to our company. We're so happy you're here. Here's a few things you should learn. That kind of thing. Have you ever seen like new videos for people who have just been hired by a corporation? Yeah, that's basically the law professors too. It's so lifeless and joyless. It makes you reconsider every life decision that's brought you to this point. They're all horrible. They're all just truly horrible. Truly horrible. Yeah. Let's move on. Yeah. Amazon Web Services further stated to Parler that the violent content on your website violates our terms. Because Amazon Web Services declared we cannot provide services to a customer that's unable to effectively identify and remove content and remove that content encourages or incites violence against others. Yeah. Professor content's giving $9.99, so nothing can be done about this. We're just at the mercy of big tech billionaire, who now control who can run for public office by arbitrarily silencing them. And you cannot have alternative avenues. Quite possibly. That might be a true statement. Yes. The law may not provide any remedy for what is happening. That may unfortunately be true. I'm not necessarily here to give you good news. I'm just here to provide, here's some problems that they're going to have. The law may not have a remedy for this. Yeah. Yeah. However, the day before on Friday, on one of the top trends on Twitter was Hang Mike Pence, with over 14,000 tweets. And earlier last week, a Los Angeles Times columnist observed that Twitter and other social media platforms are partially culpable for the riot, allowing rioters to communicate and rile each other up. Yet these equivalent, if not greater, violations of Amazon Web Services terms of service by Twitter have apparently been ignored by Amazon Web Service, which they have a right to do. They have a right to do that. Even if it is a breach of contract, it's the breach of contract against Amazon, and Amazon is allowed to waive or ignore breaches of contract against them. It's their contract. They're allowed to not care. They're allowed to not care. It's like, yeah, you've breached our contract, so what? But we care about you, right? They're allowed to do that, probably, almost certainly. And they're going to try to squeeze this into some antitrust, and that's just not going to happen. Amazon Web Services knew its allegations contained the letter it leaks to the press that Parler was not able to find and remove content that encouraged violence was false. Because over the last few days, Parler had removed everything Amazon Web Services brought to its attention and more. Well, maybe they meant that they weren't able to find it and remove it before you brought it to their attention. You weren't able to find it on their own. Maybe that's what they meant. Yet Amazon Web Services sought to defame Parler nevertheless. The statement is open to interpretation. And because of Amazon Web Services' false claims leaked to the public, Parler has not only lost current and future customers, but Parler has also been not able to find alternative web service. In short, Amazon Web Services' false claim had made Parler a pariah. That might be partially on Parler, but yeah. All right, so let's see what our causes of action are and see if see what we're going to do here. Parler cannot enforce the contract between Amazon and Twitter. That's exactly right, Tachyon. The contract between Amazon and Twitter is amazingly between Amazon and Twitter. Whoa, right? And even if Twitter is in violation of the contract and causing harm to Amazon, Amazon's allowed to say, we don't care. We waive that condition. We just don't care. They're allowed to not care. It's their contract. They can care or not care. Not caring is an option. Yeah. All right, so let's try some antitrust. Let's squeeze this into the Sherman Antitrust Act. This will be good. $5 from Joe Dufresne, I guess. Came in late, so you may have covered this. Amazon Web Services.amazon.com/agreements is the stock contract. 7.2b, I think, is relevant. Well, we'll get to the contract later. We haven't gotten that far, and we're also assuming that they signed the stock contract, which is a reasonable assumption, but it's also not necessarily true. So it'd be nice to have the actual contract Parler signed. And Matt said he sent me the actual contract. And I bet he sent me the stock contract. But we'll read that, and we'll go from there, because it's better than nothing. But yeah, it would be nice to have the actual contract that they signed, which may or may not be the same as the stock contract. Anyways, Parler restates the stuff we said before. Section 1 of the Sherman Antitrust Act provides every contract, combination in the form of trust or otherwise, or conspiracy and restraint of trade is illegal. You forgot the is illegal part. You kind of ended that. You ended that too early. That's a typo. That's a bad typo, but it's one I get to make fun of. You forgot. You left them hanging. You said, well, Sherman Antitrust Act prohibits every contract, combination in the form of trust or conspiracy in the restraint of trade. You forgot the is illegal. To state a claim under Section 1, a plaintiff must allege facts that, if true, would prove the existence of a conspiracy. Right. That's the critical part. Yeah, a contract or conspiracy. So we have to prove an agreement between the parties. They actually have to have an agreement to do stuff that restrains trade. So, yeah. So they have to prove the existence of a conspiracy, intent on the part of the co-conspirators to restrain trade, and actual injury. Good luck with that. I'm not even sure that it exists. Again, it is not, for those of you who remember the YouTuber lawyer, Laura Lesser, wherever he is out there, I hope he comes back to the web one day. This is what he used to talk a lot about when he was contemplating suing the social media companies for banning people off the platform. He used to talk about this a lot. It could be that they have an agreement, or it could just be simultaneous and independent conduct. So this is stuff Laura Lesser used to talk about all the time. I don't know what happened to the YouTuber lawyer. I hope he's doing well out there. But this is what he used to talk about all the time. So was it coordinated? Was it conspired? Or did they just all think the same because they all live in Silicon Valley and they basically have been mutually brainwashed into having the same opinion? So yeah. $5 from Q Squared. Parler is as screwed by their inability to form a compelling lawsuit as Sidney Powell is screwed by Dominion's ability to form a compelling lawsuit. Powell is even more screwed than Parler. Parler is closer to something resembling workable than Sidney is. Sidney is in real trouble. Parler's only kind of in real trouble. Yeah, Parler isn't quite as far gone as Sidney. Sidney's in real trouble. Yeah, that's going to be a real problem for Sidney Powell. I don't even know what defenses there are. I can at least, if I were Parler's lawyer, I can at least make these arguments without laughing out loud. So I can go forward and make these arguments without laughing out loud. That's promising. I don't have to agree with it or think that it's likely to win, but I could go to court and make these arguments without feeling like a complete ass. Yeah. Less than a month ago, Amazon Web Services and Parler's competitor Twitter entered a multi-year deal. Late Friday evening, Twitter banned President Trump from using his platform, thereby driving the enormous numbers of users to Parler. 24 hours later, Amazon Web Services announced it would indefinitely suspend. So they're trying to prove coordination in the timing. It's just someone. Yeah, this is just. It's equally likely, if not more likely, that someone was the first mover. And then once someone is the first mover, it makes everyone easier to follow, right? It's just, yeah, once someone does something, it makes it easier for everyone else to do the thing. It's just kind of psychology. You know, you have a first mover and then everyone else feels free to move, which is kind of also what happened probably for a large number of the people involved in the rioting in DC. Not all of them necessarily. Some of them might have been coordinated and planned, but some of them got swept up because that's how mobs work, right? Once the first person starts breaching the gates, everyone else is like, well, it's okay now, right? Everyone's waiting for the first one. Anyways, Amazon Web Services for doing so are not consistent with its treatment of Twitter, including indicating a desire to harm Parler. By suspending Parler's account, Amazon Web Services will remove from the market a surging player severely restraining commerce. Amazon Web Services violate antitrust and they're entitled to injunctive relief. Almost certainly no. Nice try, but no. Breach of contract. Amazon Web Services breached its contract with Parler by not providing 30 days notice. We'll get to the contract in a second. We'll see what they have or don't have. Parler restates its allegations. Under Washington law, a breach of contract is actionable only if the contract imposes a duty, which they would. That's a strange thing to say. A breach of contract is actionable only if it imposes a duty, as opposed to what? The duty is breached, yes, and the breach approximately caused damages. That just sounds like contracts. You have an obligation. You didn't do the obligation. The lack of doing an obligation caused me harm. That just sounds like contract law 101. Okay. The Amazon Web Services customer agreement with Parler allows either party to terminate for cause if the other party is in material breach of this agreement and the material breach remains uncured for a period of 30 days from receipt of the notice. On January 8th, Amazon brought concerns to Parler about user content that encouraged violence. Parler addressed them, and then Amazon said it was okay with Parler. The next day, January 9th, Amazon brought more bad content to Parler, and Parler took down all the content. There was no uncured material breach of the Amazon for 30 days is required in termination. Well, it depends a little bit what Amazon was thinking or not, but maybe they thought that they had to keep this is what Amazon would probably argue if I had to guess. Assuming they don't have some sort of escape clause, they're going to say we kept coming, and they weren't able to systematically deal with it. So they were a material breach. We kept alerting them to the material breaches, and every time they did cure that material breach, but they weren't able to clear the global material breach. So they're either going to argue we have some kind of escape clause that allows us to do something instantly, or if they don't have that for some reason, they'll argue they were a material breach for 30 days, and we did notify them. And every time we gave them notice, they fixed that breach, but they weren't able to solve the underlying problem. So we did give them 30 days notice, and they're in violation that way. So that's going to be what Amazon's probably going to argue if I had to guess. So while Amazon used the term suspension in its notice, it stated that it would ensure all your data is preserved for you to migrate to your own service and work with you as best we can to help you. This is not an action Amazon Web Services would take for a temporary suspension, but rather a permanent suspension. How do they know that? I mean, that's just speculative. How does Parler know what Amazon Web Services would do in a typical case with a temporary suspension? How do they know that Amazon Web Services wouldn't give this advice in a temporary suspension? Because a temporary suspension is still going to harm you. So it doesn't strike me as obvious that they wouldn't do this in the case of a temporary suspension. I mean, because you still can't use the service. So while you're temporarily suspended, we'll be happy to help you move your stuff to somewhere else. So I don't think this is the kind of thing that they'd only do in the case of a temporary suspension, or only in the case of a permanent suspension. It strikes me as the kind of thing they would do in the case of temporary suspension. And even if it's not, how does Parler know that? It's just speculative. Thus, whatever words Amazon Web Services is using is terminating the agreement with Parler. The termination will be immediately make it impossible for Parler to have any online presence for at least a week. I thought you said you couldn't find any services anywhere. So this is going to undermine your irreparable harm element of the equation. Can Parler's users sue Amazon Web Services for tortious interference? Probably not. I mean, I can't think of any obvious tort. A breach of a contract is very specifically not a tort. A breach of contract is not a tort. It's a breach of contract. It's its own little world. So I don't see any obvious tortious interference. I don't see any tort, because a breach of contract isn't a tort. Yeah. Ewan Marshall says, actually, it is following the contract in this case, but Parler are ignoring mentioning the clause. I'm sure they are. We'll get to the contract and we'll figure out what it does or does not allow for. Thus, Amazon Web Services will have breached its contract with and harmed Parler. Further lost profits in this case are difficult to calculate due to their recently increasing nature. They may be difficult to calculate, but that's kind of what juries are for. That's because the usual method for providing lost profits is to establish profit history. Well, you can look to comparable sectors. You can look to comparables. So if you can't establish it, you look to comparables. There's ways to do this. But the history will at best undervalue how given it's growing. But you can use reasonable projections of growth. There's things to base this from. And worse, Parler will get nothing, as lost profits cannot be recovered when they're speculative, uncertain, and conjectural, because the amount of lost profits must be established with reasonable certainty. Yeah, they can, and there's lots of people who help do this work. It's not exactly an unknown problem. Thus, money damages may not be available. They may be available, but they're at least insufficient to make Parler whole. They're entitled to injunctive relief. Probably not. Tortious interference with a contract or business expectancy. Okay, this will be good. Parler restates this allegation. In Washington, the elements of tortious interference with a contract or expectancy are the existence of a valid contractual relationship or business expectancy, defendant's knowledge of that relationship, and intentional interfering, inducing, or causing a breach of termination or of the relationship or expectancy, the defendant's interference for an improper purpose or by improper means and resulting damages. Good luck with all of that. Good luck with all that. Good luck showing intentionally inducing or intentionally causing a breach. Parler's current has over that isn't just an expression of opinion. Good luck with showing a tortious interference, even for Twitter. Parler currently has over 12 million users under contract. It expects to add millions more this week, given its growth. Voice of Conservatives encouraging Twitter users to switch to Parler. Watching You Daily says, in Washington state, we have an anti-discrimination protection in contract law and with businesses like Amazon Web Services. Again, to the extent that Washington law provides that you can't discriminate on the basis of political allegiance or political affiliation, you'd have to actually look into how that case law is interpreted. Because California, for example, has that as part of its law, but it's been interpreted very narrowly by the courts. So the impression you'd come away with by reading the California statutes is not a correct impression. If you read the California statutes, you'd see that you can't discriminate on the basis of race, creed, color, blah, 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 or political affiliation. So you would naturally think, which would be a reasonable interpretation, that political affiliation is treated exactly the same way as race or exactly the same way as sex because it's being mentioned in the same breath. So it's in the same category. However, the California courts have not interpreted that way. They've interpreted it very, very narrowly. So I don't think that you can rely on the statute in Washington about political affiliation because of what California has done. So without looking, I can't even begin to speak. Assuming that there is a statute that on its face applies, I can't even begin to assume that it means what you think it says because of California's counterexample. So I wouldn't necessarily rely on that in any way in this situation. And it is a matter of state law, so those states' courts can interpret it any way they want. Living Sweetly, laws of incitement apply to direct or indirect incitement. Amazon, Google, Twitter have a right to terminate for cause to protect their interests. Almost certainly yes. Almost certainly true. We'll read the contract and figure out what it does or does not provide for. Amazon Web Services is aware of Parler's user numbers and current trends, probably. Amazon Web Services also knows that Parler is negotiating with it to increase its server capacity given its ongoing expected growth. Well, if they are actually in negotiation, of course they would know. Amazon also knew a public speculation that Trump, with his near 90 million followers, would going to switch to Parler. Did you tell them that? As part of the negotiations? How do they know? Because you told them? Since 6 Grim Reaper gives me a question. Aren't they giving an argument that Parler doesn't make money? If they don't make money, where's the harm caused them? It could also be in future growth potential, that they don't make money now, but with the additional people, they make money. So they could be harmed economically from future gains. So if it's calculable, which it would be, it's like, well, we might be losing money now, but if we had the amount of users that we think is reasonable based on this growth, we would have made X, and therefore you're in breach of contract to that extent. And also, they could also measure damages a different way. They could also measure them from any increase in the price of the web service that they eventually use. So if they eventually find if they have to roll their own, or they find someone to host them and it costs them more, then Amazon would be responsible for that if there's a breach of contract. $5 from Joe Dufresne, actually extra 70 of 5 for pronouncing my name right, most don't. Well, I did see Shawshank Redemption, so I got that going for me. All right? Yeah. Amazon intentionally will interfere with Parler's current contracts and future express customer relations by terminating Parler's agreement with it on the pretext that Parler was in breach of contract. 754 of you are currently watching. Thank you very much to the 754 of you who are currently watching. If you have not done so already, may you be so kind as to please subscribe. It helps my channel grow and helps me bring more informative legal content to you. And I would really appreciate it. I really appreciate that 800 of you are here. And if you would kindly subscribe, that would be awesome to help me grow. And also like the video and all that YouTube-y stuff. It's great. At the time of filing, Trump was already banned on Twitter. Why didn't he have an account yet? I don't know. If he did, and I don't know why not. I couldn't speak to that. Why President Trump did or did not have an account somewhere. I wouldn't. I don't know. Parler will be severely damaged financially and reputationally if it must go offline Sunday at midnight because they terminate the account. Therefore, Parler is entitled to injunctive relief. Grant the motion for injunctive release, grant damages, and blah, 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 signed whatever. Okay, so that's all fun and exciting. So now we will go to the contract and we will see what it has to provide. Who will win this case? So far, we're projecting Amazon, but we'll get it. Q Square, $2 for Caddyshack. Got to get that going for me, reference. Got that going for me? Yeah, absolutely. Got to get some Caddyshack in there, man. Got to do this. So let's pull up the contract and read it and see what it does or does not provide for and how Amazon will win, because they will almost certainly win, I would imagine. If Pacer has Exhibit B, you can get the actual thing, the actual contract. Yeah, let me see if I can log on to Pacer real fast and see if the actual contract is on Pacer, because then we could comment from the real thing. So let me see if I can find it real fast. So talk amongst yourselves while I Google around and see if we can find the actual contract, because that would be awesome. Let's see. What the hell is this? All right, so I'm going to have to do this the hard way, aren't I? Plain sight script. All right, I'm going to have to log on to Pacer and actually look it up. Hold on. Hold on. I want to give you the best information possible. Rather than going on it might be the generic contract, but it would be nice to know for sure, wouldn't it? So let's see if it's available on Pacer. And if it is, we'll get it and we'll go from there. So I need the Western District of Washington. So let's go to that court. Western District of Washington, Washington State, Western District. I don't want bankruptcy court. That's no good. District court. There we go. Washington. No, not Wisconsin. Washington. There we go. Good. Now I need to pull up the query. Document filing system. Yes, I'd like to log into the document filing system, please. I'd like to run a query against this particular case number, please. All right. I'd like to get that, please. Parler versus, okay, now I need the docket report, please. I need to look at recap, please. And we've got all kinds of exhibits, correspondence between them. I don't care about that right now. The customer agreement. Is this the contract? It looks like it's just from their website. They say it is anyway. So it looks like it's just a generic one. But we'll download it anyway. We'll use the one that they provided in their official filings. This is better. It's better than nothing. Let's see, desktop. Yeah, YouTube stories. So just call this contract. Okay. Now I have to go over here, open this document up. Open document, browse, contract. Okay, great. So we'll get Exhibit B going and go from there. You should stream Pacer so everyone can see how bad it is. That's okay. I'm going to pass on that one. I'm loving the lens. Thank you, Christina. I appreciate that. $20 from the King Nola. My 5-month-old daughter gets excited when I watch you for some reason. I'd also like to see something about this Scientology arbitration ruling. I'll look into it. I was unaware of a Scientology arbitration ruling, but thank you very much for the super chat. I appreciate it. Fox says Trump joined Parler before the ban. I wouldn't know if he does or not, and it doesn't particularly matter right now. So let's just press on from that. All right, so here we have the supposed contract that apparently applies, and we'll see what provisions does or does not apply for. So this will be interesting, I guess. Let me just move that over a little bit. Yeah. All right, so let's see what our terms of service are that we've got going for us. Your account, third-party conduct, changes the services. When we change service, data privacy. You specify the reasons to store, data privacy, service attributes, your responsibility. You're responsible for all activities that occur under your account, whether are authorized by you or undertaken by you. And we and our affiliates are not responsible for unauthorized content. You ensure that your content and you and your end users' use of content or service offering will not violate any of the what? Did they submit me a shit contract? You've got to be kidding me. Did they not check their own work? Oh my God. Really? Oh, they're just sloppy as hell. Oh, this is bullshit. You see how like it just skips completely at the bottom of every page? Oh, this is bullshit. Wow, Parler did a shit job, man. They didn't even check their submissions, man. That's sloppy as hell. So you see how like at the bottom here, it just goes 2.1. So this is section 2.1, and then it just completely cuts off mid-sentence, and the next thing that happens is 2.2. You see that? How it just completely cuts off mid-sentence in 2.1 and goes to 2.2. So we're missing the rest of 2.1. Not that that's important in any way. And then does the exact same thing here in 4.2. You will ensure that your content and you and your end users' use of services will not violate any of the... You might want to... Could you, like, maybe, make sure that the copy you're submitting is complete in some way? That'd be super helpful. Wow, that's so sloppy from Parler. I hate them a little bit more. They didn't even check. They didn't even check the exhibit before they submitted it. Way to go. Genius. Just genius work, Parler. Wow. Wow. I hate them a little bit now. All right. Let me see if I can get it from the web. Yeah, it's doing the same thing to me when I go to try to print a PDF. It's doing the same thing to me. So that's what they did. They just print a PDF and they didn't bother to check it. Nice. Nice. Good job, Parler. All right, so let's change this window and we'll get it straight from their website. There we go. It looks like the pages are out of order. Even if that's true, Strange Bard, it doesn't really help the cause very much. Even if the pages are out of order, they still didn't check before they submitted it to the court. So I still hate them. Anyway. So they're there, but out of order. Maybe you should check your exhibit before submitting it to the court. Just saying, that might be a good idea, but what do I know? Anyways, what happened? Why did it change on me? Why did it change on me? Did I close the window? I closed the window, didn't I? Yeah, I sure did. Well, that was good. That was brilliant on me. I closed the window. Oops. There we go. We got it. I need to detach the live streaming window. That's what I need to do. All right, great. All right, let's try again. All right, so we have our agreement here that was last updated November the 30th. All right, so we'll see what's going on. Brian says, "Are you sure it's not a PDF scaling error?" Again, Brian, what does it matter? It's still not there / in the wrong order / not what it should be. So no matter what the reason is, I kind of hate them a little bit for not checking their own exhibit. Are you sure it's not this wrong? Yeah. Oh, you mean in the one? Yeah, it's not a PDF scaling error. All right, so yeah, it's just that they suck. All right, so we have an agreement here. So use of services, changes to the ingredients, security and data privacy, your responsibility. You must ensure you're solely responsible for development. You will ensure that your content and your end users' use of your content will not violate any policies or any law. You're solely responsible for development, content, operation, maintenance, and use of the content. End users, you will be deemed to have taken any action that you permit, assist, or facilitate any person or entity to take related to this agreement, your content, or your service offerings. You are responsible for your end users' use of your content and the service offerings. You will ensure that all end users comply with your obligations and the term of your agreement. If you become aware of violations, If you become aware of any violations of your agreement under this agreement caused by an end user, you will immediately suspend service to that user. Yeah. Fees and services, taxes, temporary suspension. All right. Generally, we may suspend respectfully uncivil law. Are you going to Sean, Shy, Spicer, Red, or is it just the screen reflection in your face? I definitely feel the respect in that a lot, Sledge Wedge. I feel that very respectfully. That's great. Generally, we may suspend your or any end user's right to access to use any portion or all the service offerings immediately upon notice, if we determine. Yeah. So we can suspend immediately if you or your end user's use of the service offering poses security risk to service offerings of it or any third party, could adversely impact our systems, the service offering or content of any customer, could subject us or affiliates to any liability, or could be found to be fraudulent. You or your end user is in breach of the agreement, you're in breach of your payment obligations, or you cease to operate in ordinary course. So we can suspend immediately for breach of agreement, the way that reads. It seems to read. So that seems to provide them more than enough authority to me. Termination. The term of this agreement will continue on the effective date and remain in effect until terminated. Under this section, any notice of termination by either party must include a termination date. You may terminate this agreement for any reason by providing us notice and closing your account. We may terminate this agreement for any reason by providing 30 days notice. So that's a separate provision, right? So we can suspend immediately and we can terminate with 30 days notice. So I don't see the problem. We can suspend you or any end user's right to access immediately upon notice if we determine you're in breach. And then we can do it for any other reason within 30 days notice. So even if you're not in breach, we can do it with 30 days notice. So if you're in breach, we can terminate you immediately. And they're going to say you're in breach by not providing for safety and all the rest of it. So I don't see a problem here. Yeah. And then 7.2 talks about termination. So in 6.2, they talk about suspension. And then in 7, they talk about termination, which is different. So we can suspend you immediately, and we can terminate your account with 30 days notice. So under B2, we may also terminate this agreement immediately upon notice to you for cause if we have the right to suspend under Section 6, which we just did. So if we have a right to cause, we can terminate you immediately, which would also be for breach of contract. So we can suspend and we can terminate. If a relationship with a third party who provides software or other technology terminates, or in order to comply with law or request of a government. So Amazon seems to have enough latitude here to suspend and terminate with immediate notice. So we can terminate if we have the right to suspend, and we can suspend if you're in breach of contract, and you're in breach of contract for the reasons that your users are doing illegal things, like making true threats and coordinating illegal activities or whatever else they're doing. I mean, you're there. Yeah, so you're there. Effective termination, all the rights terminate. You're responsible for all fees and charges. You will immediately return or destroy any content that's owned by us. And there's a license. Post-termination, unless we terminate you for service offering during the 30 days, we'll not take any action or remove from any content, and will allow you to retrieve your content. So, yeah. Proprietary rights, adequate rights, service offerings, license restrictions, suggestions, indemnification. You indemnify us for anything hold, intellectual property, process, disclaimers, limitation of liability. We and our affiliate will not be liable to you for any indirect, incidental, special, consequential, or exemplary damages, even if parties have been advised of this possibility. So, yeah, we're trying to limit our liability. Neither we nor our affiliates will be responsible for any compensation, reimbursement, or damages from your inability to use the services, including as a result of termination, our discontinuation of service offerings, or limiting any obligation, the cost of procurement of substitute goods or services, any investment, expenditure, or commitments, unauthorized access to. So, yeah, I'm not even sure they have any liability anyway. Even if they were, because it's like, we're not liable for the indirect, incidental, special, consequential, or exemplary damages. So what is the damages that we're responsible for? Not much, including inability to use service, including the cost of procuring substitute services. So what's our liability? Not much. Miscellaneous, blah, blah, blah. This is the entire agreement. Okay, great. Force majeure, governing law, disputes. Yeah, so this is the arbitration agreement, right? I'm sure it is. Any dispute or claim in any way relating to service offering or any product sold will be adjudicated in governing courts, and you consent to exclusive jurisdiction and venue in the governing court subject to these additional provisions. If the applicable contracting party is Amazon Web Services, the parties agree that provision in 13b will apply. Disputes will be resolved by binding arbitration rather than court, except claims you assert in small claims court. Federal Arbitration Act and federal arbitration law apply. There's no judge or jury in arbitration, and the court of review of arbitration is limited. Yeah, so you must follow the terms of this agreement by contacting the American Arbitration Association. So Amazon's going to say this is going to go to arbitration, and they're going to say you have a right to issue injunctive action, which is true, which the court is not going to do, and then it all goes to arbitration and the thing disappears. So it's, it's unfortunate when you know how it ends before it begins, right? Because it goes to arbitration, so therefore Parler is going to say the court has the right to issue injunctive relief, which they do, and they're going to argue about the injunctive relief, and they're going to say you can be made whole through money damages, and blah, 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 and the court is not going to issue the injunction, and then it all goes to arbitration, and Parler completely dies. So, yeah. So, yeah. If the applicable services, the parties agree this provision will apply, blah, 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 dispute by binding arbitration, of course it will. Trade compliance, independent contractors, language, confidential and publicly. You can't disclose public information notice to you by posting on the website or sending a message to the email address, which we apparently did. No third-party beneficiaries. So this means the Parler users can't sue. Nice catch by Amazon. That would be this is the Parler users can't sue provision of the contract. In case you're wondering what this is. This is the Parler users can't sue provision. Except as set forth in Section 9, this agreement does not create any third party, that would be you, beneficiary rights of any individual or entity that's not a party. So there's no third party beneficiaries, which means they can't sue us for breach of contract. That is the Parler or users can't sue us provision. Except for 9. What is 9? Indemnification, which no. So that is the Parler users can't sue us provision. Government rights, no waivers. The failure of us to enforce any provision doesn't constitute a waiver. All waivers must be in writing, severability, definitions, blah, 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 blah. Yeah, so I think Amazon's pretty well in the clear. As you would expect from them being like the largest contract provider on this service. Of course they wrote the contract to give them all the rights in the world. Of course they did. And of course they sent it off to arbitration. Of course they did. So, So Parler, the next thing that happens is Amazon's going to file a response saying that there's a mandatory arbitration clause, so this should be dismissed. And then the thing that happens after that is Parler sends a yes, that's true, but the court can issue an injunctive relief, and they should because, of this urgent need that we have. And then Amazon's going to say the need for injunction doesn't apply because the likelihood of success on the merits is low because of all the things we just read in the contract, and because there's no irreparable harm, because the damages we have are so low that can be cured with money. Parler's going to say that's not true. We do have irreparable harm because of our growth, blah, 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 blah. And then the court is going to say there's no irreparable harm, go off to arbitration. So that's about the next 6 things that happen in this sequence. It's almost like I've seen it happen before. So I can say, here's the next 6 things that are going to happen. yeah, might be something I've seen happen before. And they might dick around about it for 6 months or something. So it might not happen tomorrow. There might be a hearing on it. There probably will be a hearing on it to determine all this. And then 6 months or a year from now, they'll go off to arbitration. So yeah, all the things I just said might take a year to happen, but they'll happen. So yeah, so Parler probably should find a new home or roll their own or something, and they're not going to get any relief from this. So, no, sorry, yeah, just no, yeah. So I'll take a few questions. RP Games said Twitter uses Amazon Web Services as well. They do. Twitter constantly has violations in terms of the contract. If they're not suspended as well, isn't that arbitrary? Yeah, but they're a private company. They're allowed to be arbitrary. Yeah, it's arbitrary. It just doesn't matter. They're allowed to be arbitrary. They're a private company. They have a right. They have a right to enforce their contract or not. They can be arbitrary in that decision. They're under no obligation to be consistent in their treatment because they're a private company. If everyone in the world is violating their contracts and they don't care, that's on them. And they can still care about you because you're in violation. The only question is, are you in violation or not? That everyone else is in violation and we've done nothing about it, well, it's our contracts. We don't have to care. We care about you. We've chosen to care about you. So is it arbitrary? Yes. Does it matter? No. That can be arbitrary. That's fine. Sledgewick says, seriously, no offense intended. I hope you don't hate Sean Spicer. I just hate you for calling out me and calling out my appearance. And that would be the reason I hate you. Yeah, that would be the reason for just calling out my appearance and demeaning it. The comparison was intended as demeaning, or it's certainly read that way. Couldn't they argue Amazon Web Services interpret without good faith? Not really. I think their interpretation's within good faith. Yeah. Isn't the operative word may? Yeah, exactly. The operative word is may. As far as Parler trying to complain, Twitter does it too. Even if it said shall, it wouldn't matter. Because it's a breach against Amazon. So even if it said shall, they can't be bound to that. If it were like someone else's breach or like a third party thing, they could be bound to that. So if like there was some provision that said like in the event that some third party does this, Amazon shall blah, 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 or like that, or like Amazon has some obligation, like if this triggers, Amazon shall blah, blah, blah. But even if it said Amazon shall, if the reason they shall is from the breach of contract from the other side, they can ignore it because they have a right to not enforce their own contract when it comes to them. They don't have to care. So if the breach of contract was from the other side, even if it says Amazon shall, they can be like, yeah, we're waiving that provision too because we just don't care. So I'm not sure even if it said shall it would matter, but yeah. Computers can be hard sometimes. RP Games says, their primary attorney left them too. Yeah, Parlers, I did hear that. Who knows how hard it would be to find someone? Yeah, well, maybe their attorney left them because of ethical reasons, or they weren't being paid, or a whole number of reasons. Couldn't speak to why that happened, but attorneys can't be forced to work for someone either. So it's like, yeah, well, I don't want you. Look at the first page that has create account. They're not even logged into Amazon Web Services, guaranteed to be generic. Maybe. Or it just could be because they're really lazy, which is also a distinct possibility. Brian says, thanks for the stream. No problem. Thanks for tuning in. It's like you've been in court before. Yeah, that's right. It's like I've seen this. It's like I've seen this play before. Yeah, it's like I've seen this play before. Herbert says you should teach contract law. Entire course could be done in 10 minutes. It probably can, really. Yeah. I mean, the basics of contracts aren't hard. For there to be a contract, you need mutuality of obligation. Both sides have to give up something of value to the other side, right? They call that consideration as another word for that, which is a little fancy, but it's just basically both sides give something of value. And it can be something of future value. It doesn't have to be now. It can be something in the future. But both sides are doing something or pledging to do something, either now or in the future, that's of value to them and to the other side. So then you have mutuality of obligation. So that's a contract, right? Two people are doing something, both sides are giving something of value. And that can be in writing, it can be orally, and it can just also be by action. For example, if you go to the gas station, and if there's still gas stations left that don't require you to pay credit in advance, which I have actually been to a few. That's rare these days, but if you go to a gas station and they don't require you to pay in advance, which could happen, right? So you go to a gas station, there's no requirement to pay in advance. You put gas in your tank. So you have a contract in fact, right? The putting it into the tank it requires you to pay, right? You have a contract by the action of it. Or if you go to a grocery store and you get a bottle of soda from the grocery store and you're drinking it in the store, you have an obligation to pay for it, right? The action creates the contract. So yeah, you just, they've given you something of value, the soda or the gas, as it were, and you have to give them something of value, namely the asking price. That's you have accepted it and you have to pay, right? So there's your basic contract. You have just mutuality of obligation. By word, by oral, or by deed, mutuality of obligation. And then, if there's a breach of that duty, then you can, there's lots of different potential remedies depending on what it is. You can make them perform for it. You can make them do the thing, specific performance. That's possible. Unless it's personal services, you can't do that because that would be slavery, and slavery is bad. But if it's for goods, you can do that. So you have to give me what you promised me. It could be we could spin the whole thing backwards and just reset the thing like it never happened, so everyone goes back. It could be you have to give me the consequential damages for the breach in terms of what it takes to make me whole, because I still won the thing and I had to get from somewhere else is more expensive, so you have to pay me the difference. So those are kind of things you're looking for. So that's basic contract law 101. RP Game says, thanks for answering my question. So many live streams only ask your people who can donate. While my streams are manageable, RP Games, I'm happy to do it. At some point, my streams are probably going to become so busy that I'm going to have to make it members only or something, which is why I try to make the members price as low as reasonable, because at some point I'm going to have to filter. But as long as it's manageable, I try to be fair to everybody. I try to have engagement. Brian said, thank you for the stream. You're welcome. Just turning in. What's the gist? Is Parler likely to lose? Yes, Parler's likely to lose. They're going to fight. They're going to fight for 6 months to a year on whether or not they have to go to arbitration. And 6 months to a year from now, a court is going to say you have to go to arbitration, and then they'll go to arbitration, and Parler will lose. That's basically what's going to happen. I'm doing pretty well, thank you. Do I think Amazon? Thank you for asking, because I was sick the other day. I appreciate it. Do you think Amazon has a monopoly issue? Totally unrelated to the case. Not really. Amazon is a dominant provider. Parler says a third of all traffic. I thought it was a half. But either way, there are other companies in competition. Now, none of those companies are huge, and Amazon does have a market advantage, but I don't think they're a monopoly. And you can roll your own. So, no, I don't think so. Parler mentioned his lawyers quit. Does it matter parties attorney is a business lawyer, not a litigator? Well, that'd be a good reason not to get involved, right? He realizes his own limitations and realizes, I can't help you here. You need to find someone who's a specialist in litigation. So good on him. He realizes if you're going to go up against Amazon, you probably want a specialist in litigation. Probably not something I, as just your business lawyer, should handle. You probably want a specialist in litigation against Amazon, because Amazon's going to use specialists, so you probably need a specialist if you're going to have any chance here, right? So he's recognizing his own limitations under 1.1. He's like, I can't handle this. Good job. Q Squared says, I'm sure there's some Eastern European nations with no qualms hosting Parler. Quite possibly. Maybe Sealand will host them or something, Brian says, as a lawyer, if Amazon provides you a shitty copy of the contract, are possible issues if you clean up the copy you give to court? Amazon didn't provide the copy. Parler did. Parler provided it. And Amazon will provide a clean copy because they're professionals. Be like, well, since they couldn't be bought, they'll do it just to embarrass them. they'll make a point of it too. Well, since they couldn't provide a clean copy, we'll provide a clean copy. Since they couldn't be bothered to check their own work, embarrass them. If they're being lazy and you submit the non-logged contract to court, wouldn't that point be generic one is the one the court considers authoritative? No, absolutely not. No, absolutely not. It's a shit contract. The court will look at it and say it's not even valid because it's not authentic. It's not authentic because it's not complete. So Amazon could just say, objection, it's not authentic, and they'd be right. So no, a court won't look at this. It's not authentic. It's not correct. Because of them being lazy and being crap and not checking their work. Nate says, my lens selection skills have benefited everyone. Nate, you did provide an outstanding recommendation for a lens. Thank you very much. NW Back Country says, love to hear you discuss this and Dominion lawsuit with Nick. Rakita, seems you have two different opinions. I'd love to discuss it with Nick. Nick and I have a fantastic relationship. We've enjoyed talking with each other every time. And I'd love to talk to him about this and the Dominion lawsuit. I'd love to talk to him about it. I did catch a part of Nick's thing where he said he thought it would be very difficult to get past the public figure, which it is very difficult to get past public figure. It is very difficult. I just thought we were well there. So I heard him say, like, he thought it would be really hard. I agree with him, it'd be really hard. I just thought we were really there. So I don't know beyond that what he thinks, but I'd be happy to talk with him about it. Aaron says, thanks for going through the lawsuit. Your commentary is very insightful and entertaining. Excellent, then I'm doing my job well. Some guy with an icon for a username, which I guess we'll call him House. I thought the point of arbitration was speed things up and reduce costs. It's also the point of it is to be behind closed doors and secret so no one can tell what's happening. But I mean, once they get to arbitration, it'll be relatively quick, but they'll spend 6 months to a year dicking around about where they have to go to arbitration. And the answer is yes. Q Squared says, to be fair, it sounded like Parler would lose if they don't go to arbitration. Yeah. Sarah Cat says, not just in web hosting, across the whole organization. I don't know how they're structured. Shots Z said, I wonder if they even read this agreement before they clicked OK, like most people. Probably not. Probably didn't read it. But, that's going to be a problem. Love the lighting, nice shadows, very relaxing. I'm glad you like it. Is a hot dog a sandwich? Well, to quote Justice Ginsburg, when she was asked this question by Stephen Colbert said, or Justice Ginsburg said, you tell me what a sandwich is, and I'll tell you if a hot dog is a sandwich. And then Colbert said, well, a sandwich is almost any filling between two pieces of bread, as long as it's not more bread. And then Justice Ginsburg said, so you said two pieces of bread. Does that include a roll that has been sliced but not completely? And Colbert said, so you're getting to the heart of the issue. Because a submarine sandwich is a sandwich, even though it's a roll sliced. And she says, yes. So a hot dog is a sandwich. And then she said, under your definition, yes, it is. So I'll go with Justice Ginsburg. And that's what you think. Under your definition, yes, it is. What do you think about Apple and Google App Stores? Do you think Marsh versus Alabama could be applied? I'm not familiar with Marsh versus Alabama, but let me Google it real fast and figure out what it's about. Can't know all the cases. Marsh v. Alabama. What does it stand for? United States Supreme Court ruled state trespassing statute could not. Oh, this is company town. No, this is not company town. No, absolutely not. No, we're nowhere near company town. No. And there's case law about that. I forget. It was AOL, I'm pretty sure, but AOL was, someone tried this with AOL back in the day. And if AOL back in the day didn't qualify as a company town, Amazon doesn't qualify as a company town. So, but no, Amazon Marsh is not relevant here. Q squared, give me $5. $5 for the notorious RBG quote. Well delivered. Thank you. I appreciate that as always. Billy Mance has said, glad you're feeling better. I'm glad I'm feeling better too. Lightstone melts the things out. Gotta grab some wine. Cool. The camera setup is looking nice. Great. David Romero says, but why? Why is it not a company town? Well, you have to understand a little bit what a company town is to understand why. A company town was a town that was created, owned, and run by a company. It was usually done when they needed to harvest natural resources from a place that was completely disconnected from society. So the scenario would be they found oil somewhere, or they were going to do mining somewhere, or they're going to do harvesting a tree somewhere that's not near any town. So they need some place for the workers to live. So the company would build the place for the workers to live. They would build the housing, and they would build the churches, and they build the post office, and they build everything. And more often than not, they had their own private money. They had company money that you bought at the company store. If you ever heard that song, sold my soul to the company store, right? That's what that's all about, right? It's like get another day older, get deeper in debt because the companies would pay you in company store money and just wind up deeper in debt to the company because they charge you for everything. That's a bit of a shock. So basically, at some point along the way, they become so total that they basically become a government. They're a private government. So the company town stuff was like, well, you can't, the company said you can't do stuff on our sidewalks because they're private. And the court said, yeah, no. At some point in this equation, you became so all-encompassing, so all-controlling, that even though you're private, we're going to pretend like you're the government and you're now the government. So Amazon doesn't apply because we're nowhere near that factual scenario. You know, you're not living, breathing, eating the company constantly. It is not your entirety of your life. So that's why it's not a company town. It's nowhere close to a company town. They're not controlling your every waking, sleeping moment and where you can spend your money. They're not paying you in their money. They're not telling you. They're nowhere near a company town. No, not even close. Nothing close. You meant in reference to Parler getting removed from the app stores. What was the underlying question? I forget. Yeah. So in response to that, no, I don't think an app store is a company town either, for the same reason. An app store is not a company town. It's not even close to a company town. You know? $5 from David Stump. If Parler can point out that Amazon Web Services is not enforcing its terms of service, might they have a chance? Almost certainly not. Almost certainly not. They are not obligated to follow their terms of service with respect to any other company. It's their terms of service. If people are violating their terms of service, they can ignore it if they like. They're allowed to be arbitrary. They're a private company. They don't have to be consistent. They're not a government. They are allowed to ignore and waive conditions if they like. They don't have to, but yeah, it's up to them. Could modern company giga campuses be company towns? Possibly, yes. Facebook was looking dangerously close to this in particular, where Facebook was getting close into company town territory. With some of the stuff they were doing near their campus and having employee-led housing and stuff, yeah, some of the giga campuses with people living on site, yeah, Facebook in particular was getting dangerously close to company towns territory with some of the stuff they were doing. Is it possible to sue yourself? No. Doesn't Parler just need to show willingness and a plan for shutting down incitements to violence? No. I mean, they're under an obligation to actually do it. A plan is not sufficient, according to terms of contract. Kyle says, I saw company towns in town where they're basically municipal government. Yeah, that's basically it. They basically become the government at some point in that equation. Matt Clavar says, could you argue that the Apple App Store is a company town based on the fact that it's the only way to load apps? No, it's not. No. Now, you can argue antitrust issues, though. So you have an antitrust on improper bundling, but not company town. So you could do an antitrust thing. You could argue it's an improper bundling, improper tying, and therefore it's an antitrust violation. You could try that, which would be a lot more promising. So if you're looking for a way to get that, you could try an antitrust thing. You're still going to have a problem, though, because antitrust doesn't typically apply in situations where it's its own thing that they're constraining. It's tied to itself. A good counterexample would be like the computer in a car, right? So if you think about a modern car and the heads-up display in a car and the services that it has, it's anti-competitive in so much as they don't allow other people to be on that device. So the Honda is not going to allow apps from Mercedes on their thing, right? So, but it's within their own environment, so it's not improper tying. But you could try to argue that Apple is somehow different, and I think you could make a credible argument because Apple is in a different world. You just have some precedents. That's a problem. Terry says it was very enjoyable. Thank you very much. So how screwed are we at this point? Pretty screwed. Would a company town apply out of the U.S. for a U.S. company? Possible. Maybe. I don't know if it's ever been tried. I don't know if it's ever been tried or not to try to do a company town for a U.S.-based company outside the United States. I don't know if it's ever been tried. Also, you have whatever domestic laws in the country that you're in that may be dominating here. So you'd first look to the home country, the country that business is in. But if you had an American company doing business, could you get to company town? It maybe. So Parler is going to join the Fortnite lawsuits? Probably not. Is AdSense an illegal monopoly? No. I don't see how it is. If you want to buy ads from Google, they have AdSense. Probably not. Yeah. There are plenty of ways to load content onto phones. That's also true. Congressman Ro Khanna has been calling for Parler to be removed. Could that be considered the government suppressing free speech? Probably not, because she's not an executive branch official. She's just one random member of Congress. So she's just expressing an opinion. She's protected by the privilege. She's protected by the speech and debate clause in what she's saying, and she's just expressing. She's a right to an opinion too. So I don't, and because it's just one random member of Congress, I don't think that you can see that as governmental action. The antitrust argument is very thin. I wouldn't go so far as to say idiotic, but it's thin. It's very thin. It's not going to work. I wouldn't go quite as far as idiotic, but it's not going to work. There's a lot of competition in online ads. That's very, very true. Yeah. Can I sue someone for accidentally spilling mustard on my shirt that I let them wear? Sure, I suppose. If they were negligent and caused damage, but that would be a really stupid idea. You probably should just have it cleaned and call it a day. Am I feeling okay? I'm getting better. I was feeling very sick on Sunday, and I'm feeling much better today. Thank you. $5 from Will Clem. If Facebook would have done their cryptocurrency, would it have made them a company town? No. Because they're not buying and no, because they're not paying you. If they were paying you in it and they only accepted it, then maybe. But merely doing their own cryptocurrency, no, it's not a company town. especially if they accept any other forms of payment, which I assume they would. They're probably not going to stop taking cash and checks and stuff. But merely making their own cryptocurrency, no. When you think in company town, you have to remember how all-enveloping company towns are. I mean, you live, work, eat, breathe, go to church there. Your police is private security provided. The fire department is private, provided by the company. The roads are by the company. You have to remember how all-encompassing company towns are. No. I don't get what Parler is suing, moving to another home company or buying your own services. The damages is being caused, maybe to get some press. The Parker Brothers monopoly. Q Squared says, today I learned you got COVID. I don't know if I had COVID or not. I'm feeling a lot better, though. Yeah. If you're still interested, my question is, if Amazon Web Services gives Parler a shitty copy of the contract, then Parler edits it for readability as opposed to pass it as it were, as a risk to Parler? No. If they merely change the font or something to make it more readable, then that's fine. As long as the words on the page. If they changed it to change the font or make it more readable, I don't think that's a problem. So if that's the nature of the editing, if by editing you mean did they delete words or add words, then yeah, that's bad. You can't add or delete words to the contract. You actually have to provide the contract. The contract is what it is. You can't, if it's unreadable, it's unreadable. That's part of the problem maybe in the contract, but no, you can't edit the contract substantively. If you want to argue it for style, then sure. If you want to argue for substance, no. Wouldn't all accidents be considered negligent? Not necessarily. You could have an accident without it being negligent. Because actually a faulty mustard bottle with a soupy mustard company over my damaged shirt. Why are you suing for this? This seems lame. I suppose you could sue them for product liability, maybe. Why? It sounds like they're saying since Amazon's PDF is messed up, it's on them. No one's saying anything about the PDF. I'm saying about the PDF. The only thing that's been filed so far is from Parler. Amazon hasn't responded yet. Amazon isn't saying anything yet. They haven't responded. I'm simply noting that Parler has submitted a shit copy of the contract because they didn't check their work and they're lame. I'm saying they're lame. Could the government court screwed up in the PDF? No. No, this is definitely Parler who screwed up. This is definitely Parler who screwed up. Well, with that being concluded, I'm going to sign off. I've enjoyed our time together. If you have not done so already, please subscribe to the channel. It helps us grow, and I'm thankful for all the people who've been subscribing lately and helping the channel grow. It's been really awesome. Thank you. And it encourages me to continue producing content and encouraging to interact with you. I really enjoy it, and I hope you do too. If you've not done so already, if you'd please like it, that would be awesome. That'd be great. And for 99 cents, you can become a member of the channel and help the channel grow that way. Until later, my friends, cheers and goodbye.